हेलो कोर्ट ऑफिसर अनिल भाई హలో
హలో
నేను నా మాటలు నోడుతున్నాయా
వినబడుతున్నాయి. ఏంది ఇట్లా ఇట్లా ఆన్లైన్ లో చేస్తా
కొద్దిగా వేరే ఫంక్షన్కి వెళ్తున్నాను అందుగురించి ఒక మ్యాటర్ ఉంది ఫస్ట్ మ్యాటర్ చేసుకున్నాను
మరి నాతో ఎందుకు మాట్లాడుతున్నావు?
నాకు వాయిస్ చాలా స్లోగా వస్తుంది కొద్దిగా వాయిస్ పెంచారా
నేను మైక్ కు దూరం ఉన్నా.
అవునా సరే సరే ఓకే ఓకే థ్యాంక్ యూ
ఆన్లైన్ ఇట్లా కూడా ఎందుకు చెప్తున్నా?
లక్ష్మి ఇది రావట్లేదు.
Page number 1, item number 1 to 90. Page number 2, item number 22. Page number 3, item number 23 to 35.
Yes. Hi, madam. Item 23. We'll see when it reaches. Any cast survives, we'll definitely consider. Yes. Why? No. We'll examine whether it is required to file any reply or not when it reaches. Yes. Yes.
I like to file documents. Asking me kind of.
What documents you want to like?
Recently, the accused opposed and he has given undertaking.
This is the submission you made last 4 weeks back also.
Due to this trouble, I could not.
Yes, at the request of the learned counsel for the party in person. Is this on 13/12/2020?
Page number
29.
Yes.
Because for 2 weeks of time, IA has to be filed.
Have you informed other side? Yes, at the request of the learned counsel for the parties. Is this case, when do you want? Is this case on 29/11/2020?
Page number 4, item number 36 to 49. Page number 5, item number 50 to 61.
My
Yes.
lordship, item number 44.
Yes.
Kindly have it after 2 weeks, my lordship, due to personal inconvenience of the council.
Yes. Is this case on 6/12?
Yes, my lordship.
Page number 5, item number 50 to 61. Page number 6, item number 60 to 80. Page number 69.
Yes.
We have received counter yesterday.
You are appointing? Yes, at the request of the petitioner. List this case on 13/12.
Page number 7, item number 81 to 101.
Lordship,
Yes. Your good name, please. Task on pair. Yes.
Lordship, item number 88.
96.
Yes. Yes. Yes, madam.
Lordship, item number 88. There is an urgency, Lordship. Kindly, it may be taken up in lunch motion, Lordship.
What is urgency? What is the matter?
Lordship, already notice has served, unofficial responded, Lordship.
What is
There
urgency?
is no,
What is urgency? Tell me first.
Lordship, implementation of injunction orders, Lordship.
Implementation of injunction order, you have to go before a civil court, not before this court.
Lordship, lower court is not taken, Lordship.
No urgency. Yes. When it reaches, you argue the matter. Yes.
Page number 8, item number 102, 114. Page number 9, item number 150 to 180. Item number 1, unless we have. Again.
May I please, your lordship?
Yes. What is the matter, Mr.
Release of vehicle, my lord. Ordered by your lordship, order, my lord, page
Excise offense.
19, my lord.
What is the vehicle?
Vehicle Ertiga, Maruti Ertiga, my lord, 10 years back vehicle, my lord. He has given his friend for preliminary, my lord.
Yes.
Item
Your
number
lordship, amount.
180.
Yes. Yes.
The private responsibility for roadside has requested the petitioner to sell the payment. But the substantial amount is the petitioner he wants to let the way for bike. So what they have done is the adjacent land belongs to the open land. They have raised suddenly overnight the structure and written out their church. They want to play mystery because you want to know the rule 100 meters from
Yes.
all those things. Now the exchange authorities were hesitating to grant the final permit in favor of the petitioner because of the existence of the federal body. The police complaint was given. Police have made an inquiry. If you also kindly see page 26, police have made an inquiry, and they have stated that this is suddenly the overnight was come up. Kindly see, 7th paragraph at page 26. As per the allegation leveled in this present petition, the alleged
Page
26.
Yes. Paragraph.
Paragraph 7th paragraph.
Yes.
Number.
Yes.
As per the allegation leveled in this present petition by any person, Kishan Gaur and other business associates are trying to erect a church to avoid to create the hurdles to the new wine shop which is going to open near the wine shop and its property. It's clear that there was no Christian activities in church seen till the date of Krishna's property, and on the inquiries of the municipality, there was no requisition filed by any person to erect a church or Krishna's property, and no such orders passed to municipal authorities. Even though it is established that Sai Krishna and other associates are trying to open a church suddenly, and the entire matter is pertaining to civil in nature, hence they complained to request to file a complaint to the government to the authorities. Overnight, they have erected photographs also I placed before Lordship.
What remains if interim orders have been granted? What remains in the writ petition once interim orders have been granted?
Well, the interim order is to direct the excess of our case to consider grant of final permission to the petitioner.
What remains in the writ petition?
In fact, there's a prayer in the main writ petition also, because this is a mischievously raise the construction. Photo at the page 61, kindly see page 60.
Page
60. A small structure, bottom photograph. A small structure made at a overnight, made a lady Mandiram church. Written on that. Just to holding the authorities and also to see whether the final permission is not granted favor to the petitioner.
What is
We get instructions in the lodging, and the representation was given on third itself, so only one day was elected, so we get instruction. And municipal authorities also not made the party to verify that the church is made as per the permission on it.
That's a very small structure made overnight. Page 23, the confirmation letter granted in favor of the petitioner by the excise authorities.
It will be taken from Tuesday.
Let them get instructions. I will consider on that day.
Yes.
Yes.
Kindly the motor.
Yes. Not necessary now. Notice. Yes. Get instructions first. List this case on Tuesday. List this case on 15/11.
Item number 3, Muhammad Adnan.
Yes. 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 What is? See, if you want to arrest the petitioner's brother, what way the petitioner is involved in any of the case?
No, ma'am.
Then why? Ready? Petitioner is an advocate by profession. Petitioner is an advocate, practicing advocate.
The action of respondents in high-handedly and calling the petitioners, companies, employees to the police station and harassing them with threats. Fellows, petitioner company is a facilities management company for a particular building in Raidurgam. There are different software companies. Out of 130 commercial units in that building, 90 of them have engaged the services of the petitioner managers. Now, petitioner has said, if you have not paid money, we will not provide our services to the remaining 31 people. Now they go, now police is getting involved in this issue and is trying to call the employees of the petitioner company to the police station. In fact,
Yes, what do you say?
I have also filed
What instructions you need to give?
In fact, I have also filed page number 33 minutes. I filed photographs of police coming to the building minutes on 311 minutes.
And want to get instructions tomorrow? Let them get instructions by tomorrow. At least tomorrow. After sir, it will reach.
Number 5, Mr. Veerabhav. The action of the Secretary may not without following the procedure may not issue the proceeding number page number 14. Without showdown notice may not without 117 order may not that pass the orders may not page number 14 may not On 26/10/2021, false case was registered against the petitioner Mellon. And immediately next day Mellon issued proceedings Mellon. On 27/10/2023, taken out to the police station to the morning to evening, they produced before the second responding to the magistrate office, night Mellon. Taken out put in the proceeding. Without given opportunity also Mellon.
Yes, who is appearing? Have we passed any order under section 117 of the CRPC before passing an order under 122 1B? Yes, interim stay.
There is a petitioner.
Petitioner is, what is that evidence to say that he is a rowdy shooter?
Only recently other political party joined. He's an MPP, except what in fact the FIR. One case is registered, demand the judicial demand. Immediate another case registered, issued.
Admit interim stay. Yes.
Number 3.
Is this case on 13/12?
On blood of candidates was the every day they call it to the police station was the. This is not. The second number to be like till they lost their car without when they are against was the petition.
Right. Follow the procedure.
Okay.
Yes. In case of the petitioner is. The petitioners, the case of the petitioners is that they are doing interior designer works and also doing real estate business. Mr. The state
And they could not pay the amount that they excluded the registered sale in that page for 16. Eliminating the entire land in survey number 979 by A, within 2 acre foot by Bunga. Then sale has been executed in favor of the petition on the same day that Darwin Patadar passed for issue in favor of. He also, the petition also blood pencil to blood iron fencing has been there in that land. Now the response, announced the response to go to the land. Again, responsible to the land, not describe the entire fencing blood, I filed before the press. And also filed the complaint before the police, that the police have not been acting upon the complaint.
Yes, what is?
Yes, there was a complaint. There is a TSHC.
File a protest petition. You file a private complaint. You are having a two options, Mr. Damodar Reddy. One is you are entitled to file a protest petition under section 202 of CRPC. And you are also having a right to file a private complaint under section 200 seeking reference under 156(3). Automatically police will register a case. Why you want now file a writ petition unnecessarily? This court want to have has to give a finding on the rights and merits and demerits. We don't know whether you might have been also removed your fencing and file a false case. I can't examine all these things in the writ petition.
I placed before them not be registered sale executed by the.
Now in view of, see, even you are aware, once the complaint has been closed by the police, concerned magistrate is having power not only taking cognizance on the referral complaint, but equally in a protest petition, even otherwise also is entitled to take cognizance of the complaint and issue summons directly. You are aware?
Yes, that is there.
Go there, yes. Right. The case of the petitioner is? Petitioner? No. The case of the petitioner is? Show me the sale deed. Where is the sale deed? Show me the sale deed.
Page number 16.
Page number
16, 16.
1?
16.
Yes.
Yes, let them be done in favor of Veerabhadra Swami. The share of placing blood 10,33,856.
See, with the balance amount is liable to pay. Are you ready? Because the 10 lakhs 33,856 you have purchased the property.
Yes.
Now we will put an auction in the court. 20 lakhs rupees. Are you ready to dispose this property in favor of the third parties? Because you have purchased 10 lakhs only. I am exercising my judicial review powers under Article 226. You have purchased only 10 lakhs from the third respondent. Now an offer can be given by any person. Vijay Parapakar is here. He will give 20 lakhs. Are you ready to dispose your property in favor of this gentleman? Sale deed is only for 10 lakhs. And in fact, he is liable to pay 30 lakhs. In fact, he is liable to pay 30 lakhs. No. Therefore, when you have purchased the property below the market value, or when you have purchased the property, even though the respondent is liable to pay an amount of rupees 30 lakhs, a sale deed has been executed to you by the rate of rupees 10 lakhs per acre. 10 lakhs. We will put an auction of this property in the court. If any party ready to purchase, Mr. Damodar Reddy, I am saying that you have purchased the property of 2 acres 25 guntas at the rate of rupees 10 lakhs 55,000. I will put this property, which is a dispute after notice and an auction. Any person can purchase the property, and whatever sale consideration you have paid to him, he will pay back that sale consideration.
That is 30 lakhs, that is the.
Right. Don't say all these things. We know that how to deal with the cases also. There is a provision under the income tax also. When you purchase the market property below market value, income tax can pay the sales and consideration. I will refer this. Forget about the sub-register. We know about sub-register and tahsildar. Yes. You must know.
The third respondent has obtained a loan of rupees 30 lakhs.
It is the case of the petitioner. The third respondent has obtained. Yes.
Paying before from issued by the respondent would be to the petitioner. In fact, also money from 2025 dated 11 October 2023, and this extending debts to the employer of the petitioner.
What is that notice issued by the respondent?
The notice has been issued to add gold ornaments. The petitioner company, the non-manufacturing institution registered as company, Indian company in India Act, having registration issued by the Reserve Bank of India. The petitioner company has branches throughout India, and one of its branches is international. As part of its business, the petitioner company branch loan to its customer or associated with gold ornament pledged by them. The nature of the business of petition company is that the customer approach the petition company for loans by pledging gold as security. The RBI registers the certificate is filed as exhibit C2. But during the course of business in 21 August 2020 and 9 September 2023, the petition company at Gulchurch branch was approached by the respondent of the 5 and 6 gold ornament
stating that they are lawful open for petition in confidence with the RBI guidelines to not to all the relevant KYC details, undertaking forms and after due verification petitioners provided gold into the respondent for 506. By separate receipts, contract proposal amount of more than 180,000. Lordship, the de facto complainant, that is the respondent number 4, page number 14. The de facto complainant, the respondent number 4 getting and lodged the complaint at the police station on 8 August 2023 based on allegations against the respondent for 506 crores. Here, accordingly, FIR number 180 of 2023 of the file of respondent number 3 was registered under section 387 506 for the electric. The FIR copy has been filed here with the P6. Lordship, thereafter, logging the FIR, the respondent number 3 apprehended the respondent number 5 accused number 1 and 2, and the alleged accused immediately confessed, stating that they
Yes, what do you say? You have not received any affidavit. Yes, get instructions.
at least the person who
Yes. Why let him get instructions? I will grant an order. Why your necessary personal notice? You will see. Monday, list this case on Monday. Saru set up papers on other side. Yes.
And they filed the petitioner to the police station the petitioner to settle the issue. Because the police station
Yes, what is? Yes. List this case on 15/11. Not as reach.
number 10.
Yes.
The action of the both respondents for the improper and fair payment case. The petitioner is the victim in the offense. The petitioner is the injured person. And it's the affair, complainant affair.
Yes.
Case number 12. The accused persons A1 to A7 along with unofficial response attacked the petitioner indiscriminately. But the both respondents registered FIR section 448, 324 and 506 surrendering that for a IPC. Later on, the section was ordered to file this with a charge sheet number 90.
Page number?
90. 19.
Yes.
Order to 448, 290, 325, 506 surrendering that for a IPC. In fact, the wound certificate.
You are entitled to file an appropriate application under section 216 CRPC. You are not following the suggestion being given by the court. So this material can be considered by the competent court for altering or adding any of the provisions. The competent court is always having power to alter the charges. Section 216. Now, how can I examine all these things in the red jurisdiction?
Under the influence of political.
You are not following. See, even if IO has filed such a report, the court is always having power to alter the charges which have been framed in the charge sheet.
Only request another IO will have to conduct further investigation.
What is that further investigation? They have already filed a charge sheet. Therefore, you file an appropriate application before the concerned court saying that this is the material evidence available. Instead of making a charge in particular provision of law, they have colluded, and therefore these are the charges has to be framed against him. The court is always having power under section 216 CRPC to alter or add the charges.
They will not entertain.
Who said that they will not entertain?
And this is the wound certificate.
Therefore, I am not. This court is not having any proper authority to examine the same under Article 226 of the Constitution of. When a court specifically conferred with the power under section 216 CRPC. You read section 216 CRPC. You read first sections 216 CRPC. Have you verified at least 216 CRPC? Read.
Section 3 of.
Any court may alter or add any charge at any time before judgment is pronounced. And even for improper investigation being conducted by the police, you are entitled to file an appropriate application before the very concerned court.
Clear rules are there. They try to kill the petitioner. There is a civil dispute between the petitioner and unofficial respondent. That the clear rules are previous in nature.
See, simple admitting the case, it won't survive your purpose. It will be pending here for 10 years. Meanwhile, trial will be completed and a case will be over. Rather than that, you withdraw and file an appropriate application before the concerned court.
Let them file counter mirror.
Yes. Petitioner is permitted to take out personal notice to the respondent 527, 528 and file proof of service. File a counter. List this case 13 to it.
Number 11, Mr. Rahul Bhaskar.
Yes. First, you read the complaint. Page number? Yes.
Depositing of a bunch of in the various banks, and need to give levels and the black prices for part of additional amount. And cheated a teacher in black value on the number of pilot parts.
It is purely relating to a settlement between you and your wife.
Exactly.
So what is the complaint?
The response number 7 is the one.
If there is no cognizable offense, you close the complaint. Yes. List this case on 29/11/2023 for instructions.
Okay. Item number 12. Given for association. Correspondent for action of and the third petition not regards the property diversion of the district if you want to erect a gate mirror back. It is not a common path. It is you want to erect, but that will not be erected to the responding step to and before there being any complaint, the petitioner and his father were called to the police station on Friday 3rd, and they were threatened that the analyst should stop the work to taking the custody.
Yes, sir.
Stop the work. And I went to photograph when they have to get based on this. Police and how they better be. Right from yesterday evening also it started. And I find a cabinet also. They have got any grievance that they put civil court and they
And the petitioner claims to be owner and possessor of house bearing number 1-8- We'll get it, we'll get it.
This request is filed challenging the inaction of the respondent number 2 in conducting an investigation for the FIR registered against the accused.
Yes.
We registered the FIR in 11th February 2023. Till now, they have not conducted any investigation and they are saying that there is no evidence against the accused.
Yes, what do you say? See, furnish whatever information you are having.
They don't acknowledge the documents.
You send it by registered
I
post.
sent it by registered post. Yes, sir. Document page number 25 to 28. I've sent all the documents.
25 to
28. I've sent the documents registered post and this tracking report is also there.
yes. What do you say? What appropriate action you will take? You issued a notice under section 41 to the accused. Is the accused submitted any explanation to the 41 notice? And why you are waiting? And only to prolong the litigation to favor the accused, you have issued a notice under section 91 read with 160 to the petitioner. And petitioner also immediately replied by furnishing the information as required under section 91 CRPC. Still, you are not proceeding with the investigation. What is the difficulty for you for conducting investigation? You have not received any material instructions. You are waiting for material instructions from the petitioner. Yes.
2 months.
Petitioner is a limited company. This is Bhaskar. What is the problem? All cases filed by you is only 154.3. They are not acting upon. It is because of.
That's very well.
Yes, what do you say? Why you are compelling the persons to file a complaints to the various superior authorities? Then you have not acted upon, they are compelled to file a complaint under 154.3 to the Superintendent of Police. You want to get instructions or you want to dispose the petition? List this case on 22/11.
Item number 50, Mr. Venkatar. Item number 60, Mr. Ajay Kumar.
Maximum of 5. Yeah, involved in civil dispute. Police officers are included.
Yes, what do you say? One is ready. The petitioner claims to be owner and possessor of the land bearing land plot to an extent of 726 square yards in survey number.
And at the same time, the petition is good. So also for third time, and second time, you got the complaint is passed. But are we having another things? We write this in the price, 41 was ordered.
Yes.
Compared to the order, it's the right to say me. Then I had an appreciate you also publish at page 23.
Yes.
Now, at page 41, they have frozen my account. Demat account. Basis of receiving bills. 41 they say that we have reached this account. 44 reason is given by this person.
44? Yes.
They have said that in guidelines, right? We have present here.
Where is that? Where you are reading?
Not sense, upon the 48. On the bottom further.
Yes.
For the book, the dean of the county brought due to the police complaint, FIR announcement.
What is this crime register 1032 of?
Section 498, 3 and 4, 4.
See, when it is a offence being registered under section 498A, read with 3 and 4 of the Dowry Prohibition Act. What way the account of the petitioner is concerned for freezing, or what way the account of the petitioner is required for the purpose of freezing? It is not that the offence being involved under section 406 or 420 IPC. It is only an offence being registered under section 1032 of 2023. How the police are entitled? You read section 102 of the CRPC, what it says. 420 is there. Yes, 498A, 420 is there. For the purpose of 420, they are entitled.
Section 109.
Section?
Section 109 of CRPC. They must immediately 102.
Obtain the permission from the concerned magistrate. Yes. Not under 109. 102 of.
102.
I have dealt with the section 102. I have allowed number of writ petitions. Let them file counter affidavit.
The paragraph is CA, page 21. And it's frozen on 26th. CA was filed to find out whether the information was given page 21.
Page 21.
21.
Yes.
It is written on 27th.
Yes, have you obtained any permission from the concerned magistrate?
We need to file counter.
File it by counter. Yes. List this case for filing counter affidavit on 22nd 11. I will on that day I will dispose of the writ petition. Not necessarily you make a mention, it is a freezing of account. I have already passed so many orders, so many writ petitions being allowed by you. Yes.
Number 18.
The ఖర్చు వచ్చిందమ్మా. ఇదమ్మా ఖర్చు వచ్చింది. కింద పడ్డారు. Yes. Yes, Mr. Praveen Kumar. Yes.
During the election period, it is mandatory that
But there is no mandatory for providing police 2+2 security. There is a GO issued by the government. A committee being constituted. And after conducting a threat perception reports, after calling for threat perception report, they will verify whether a necessary protection is to be provided or not.
during the election.
The petitioner is a candidate from PSP party from Uppal. He is a friend of super knowledge is practicing in our court. We have provided 1+1.
You have already provided. Then what more you require?
The PSP party unrecognized.
See, I will direct the police to provide 2+2 security to you, subject you are bearing the cost of the personal security.
Yes, yes.
Are you ready? Get instructions.
The 1+1 not to be kindly
We have provided.
No, he wants 2+2. You provide 2+2 and collect the security charges from him. Every day it may charging about, every month it may charging about 1,20,000 approximately. Let him pay that amount also. You make an inquiry, you can get instructions from the concerned people that the petitioner has submitted to the court that he is ready to bear the expenses. No, as according to as on the date you have provided 1+1 security.
Because he is a candidate from PSP party.
You recognized political party. What more you want? 1+1, we don't get 1+1 security as a judges.
Petitioner was unsuccessful in getting 2+2 earlier.
If this fact is known to so many people, everybody will try for getting a ticket from the parties also, whether even though there is no possibilities of being elected, but at least for the security purpose.
But we have provided 1+1.
No. What is that instructions you have received from the concerned authority?
We have provided 1+1.
Oral instructions you are saying. You are aware. You get instructions because you are aware that only the Advocate General statement is binding on the government, not by the government leaders. You make an inquiry with the, if you want to record? Yes, Randy. This repetition is fine. Seeking following relief. Item number 19. Yes.
My complaint is at page number 15. The petitioner is a tribal who ensures in her land. The accused entered in trespass into the land and accused.
Read your complaint.
Page number 15.
Yes.
I'll exclude all the names and start from. Kota Vijaya Datta.
Yes, why you have not registered the crime? The complaint discloses very cognizable offence. Let him get instructions.
But, Monday,
This is the petition for instruction on 22 level. Yes. Not necessary. Reaches all cases which is subject to your cooperation. Yes.
Chapter number 20.
Yes. Yes. Page. Yes.
I was pursuing of the person of the short game. To respond and last taking inaction of respondent order. Even after withdrawing the case, the FIR and CC on me, 24th November 2020. And I landed in Hyderabad.
Issuance of LOC.
LOC is there, but it is not in withdrawal. Still it is there.
Yes.
They are already loaded.
Randy. What more you want? They have already addressed a letter.
Page number 42.
Page number.
Page number 42.
Yes.
When I landed 16th November,
Yes.
this year in Hyderabad,
Yes.
I was made to sit
Yes.
at the airport and I was taken to KBHD and made to sit 1 p.m. next day.
Then you have addressed the letter to the. See, 1710, 511 recently they have addressed.
There,
You are not following. What is the procedure when the LOC has issued against the petitioner? Tell me.
these
So what is the procedure has to be followed? Tell me the procedure, that's all. See, the moment the cases have been withdrawn against you and there is no case pending against you, or a notice as required under section 41 CRPC has been issued, or a case registered against you has been passed by the competent criminal court. Since there is no cases pending against you, the said information will be furnished by the concerned station house officer or the inspector of police to the commissioner.
Yes.
Commissioner in turn address a letter to the bureau of what is that? Hmm? Yes, immigration officer. They will close the complaint.
24th November 20.
See, you have requested you have read the representation dated 17/10/2023. They are saying on 5/11/2023. Today, what is the date? Today, what is the date?
Till the 8th.
See, when you filed a writ petition.
7th.
When they have, according to when they have addressed a letter. And how can you know that whether they have taken an action or not?
Only reason is I have going back to US.
Go there, go US. Give a copy of the letter addressed by the Commissioner of Police to the petitioner. Therefore, he will produce if it is necessary.
And whether this IA can be disposed directly 1 and 2
What is that IA?
to withdraw the problems. Last year. That is the pending with
You give the instructions, copy. Yes, Randy. The petitioner. Now divorce is over.
posted for 27. 27 of this time.
The petitioner.
And it is a mutual life.
The petitioner is the husband of the fourth respondent. There are matrimonial disputes between the petitioner and fourth respondent. The fourth respondent has lodged a complaint. The file of the respondent You should know the mind of the court.
Please.
When I am allowing your writ petition, you are intervening into the matter.
In view of the said submissions.
In view of the said sufficiency, in view of the said sufficiency, this court deems it appropriate to dispose the writ petition, directing the Commissioner of Police, directing, you have not made
Number 21. Second.
yes, Mr. Yadav.
Every year after the Deepavali festival, after 2 days of the Deepavali, the Yadavs in Hyderabad conducted Sadar Mela.
I know that, argue the matter, I know that, yes.
Traffic knows the Sadar better than me. But this year we have page number 11.
They are not granting any permission.
Without any reason.
Yes, what do you say?
Whether 40 years of people permission for the event bandobast at marriage function on.
No.
Unless they have rejected marriage.
They have rejected order, kindly see page number 11. Your application has been rejected due to the following reasons. As the date of event has been closed, hence the petition can be closed.
What is the, where is your application for that?
My application page number 15.
Permission for event of bandobast at marriage functional, what is this?
Because online application was they have rejected. But subsequently has given a return.
1 minute. See, I will direct them to consider the representation submitted by the petitioner dated 4/11/2023. And it is a customary right of the Yadavs to have a Sadar Utsav immediately Diwali. You consider there is no law and order problem from the Sadar Utsav. You consider. No, I will only direct the police to examine the representation dated 4/11/2023 and permit Yadav Sangam to have. What is that welcome stage? What is that welcome stage?
You have to process in going on that some water.
I will direct you to examine your representation. And what is this representation? There is no meaning at all in the representation. Celebrating Yadav community. So far as the second paragraph sentence, first sentence is correct. Yes, you are right. Sadar Sammelan is celebrating. Yes, Randy. This repetition has been filed. Questioning the action of the respondent police in rejecting the application submitted by the petitioner.
Madhavi garu.
Yes. What do you say, madam? See, whether you appear or Madhavi Lapta appears, the result is one and the same. I will record is sufficient that they have already closed the complaint, leaving it open to you to state your rights before appropriate forum. Yes, right. The case of the petitioner is that he entered an agreement of sale in the year. Yes. Yes. Verify whether anything survives in this petition. Yes, what do you say? Complaint has been registered as in the year 2007 under section. Is it pending as on the date? Yes. What final report? 2007 case. What is the stage of the case? You might have filed a final report long back. The case also, either way, it would have been disposed by the competent court. You get instructions by 2:30. Or you counterfile. See, according to you, when you file a final report, see, they have also filed, madam. They have also filed a report on the file of the executive magistrate under section 173 CRPC. Yes. You have not received any counter. Yes. Serve a copy of the counter on other side. List this case on 29/11/2020.
Number 24, Mr. Vemal.
Yes, when? Nothing else is there. You want to argue tomorrow? I have given already 29/11. What happened? Why you want to impeach central government as a party?
This is regarding the citizenship of the petitioner. There is no termination of citizenship of the petitioner.
Is any citizenship has been granted to the petitioner?
She is a citizen of India. Born here.
But you married the Pakistani.
Thereafter, he take out petitioner to India.
You know, Pakistan is only not only naked out Indians, they have also naked out Afghanistanis also.
There is no termination of citizenship. As long as she is a citizen.
The moment you acquire the citizenship of Pakistan, it is deemed that automatically Indian citizenship is terminated.
Section 9, unless an order is passed to terminate the citizenship, that she continues as a citizenship. She married India.
Is it permissible under the Indian Citizenship Act that you are having a dual citizenship?
Overseas citizenship is like, yes, it is there. The Lashman kindly consider in this case, let's add that citizenship is not at all terminated. That's why you are asked to subject the central government will not manage the party.
Yes, who is appearing for the central government now? You are appearing for central government. Survey set of papers to. Yes. Your appearing means Praveen Kumar appearing, or it is assigned to somebody else? Yes, guard Praveen Kumar takes notice on behalf of the implied petition. Guard Praveen Kumar takes notice on behalf of the implied respondent and seeks time to file counter affidavit. Implied petition is ordered as per the reason stated thereunder, and the implied. Says who is appearing for CHC Mas? The service matter, why it is listed before us? The relief sought in this petition is relating to the service matter. This case, list is directed and list this petition before the appropriate bench hearing service cases. Yes.
Number 46, Mr. Lakshman Kancha.
Mr. Imposing fine of 1 lakh 5,000. I think it is only mark.
Commissioner,
Imposing fine of 1 lakh 25,000. Lease of the vehicle. Here the sample for should deposit around first you take the other.
vehicle was already released. Here is the order of the commissioner. Page number
9. Last one.
yes,
The 8 craft. The number 10 8 craft.
yes.
Mark and fine of 1 lakh 25,000. But the one was the vehicle and
What is the vehicle?
not vehicle, but never.
What is that vehicle? So it is not costing about 1,25,000 according to you. Varna vehicle of 2011 model is not fetching a rate of rupees 1,25,000 market value. It's a discretion exercised by the commissioner. You file a revision. You file a revision before the government, questioning the orders of the commissioner. That is
3 lakhs to 1 lakh.
which court has modified.
Posing this. 3 lakhs. Vehicle or the lorry vehicle. Sample for lost the 3 lakhs. Sample for last.
The petitioner claims to be a registered owner of the vehicle. Have you filed any application? Have you filed any application, the seeking dispense with? When he was appointed as assistant returning officer? When he was appointed as assistant returning officer? 13? Then 11th July 2023 was appointed as an
Clearly appeared that he appeared and he signed counter merit. He failed to produce the regards merit for that reason. This honorable court that one second.
according to you, it is not Form 1. It is only because he failed to produce the records. This yes. Yes, what do you say?
Last may look at the last flag melody. That also that she stated that merit she is not ready to give the documents merit since the court case is pending before this. Once the case court is closed and is ready to give documents. And don't be that we send one more notice on 28/3. But 28/3, 28/2/2023 was also from the bar.
Yes, what do you say? Why is they have issued a notices? And in fact, the second notice specifically says, by notice dated so and so, you have been directed to produce the documents within 24 hours, and you have received the contention of the court case is pending. Contention of court case, contempt case maybe is pending on this issue. Once the court case procedure is done, we will furnish all the documents requested by you. What is it mean? Who is Shamala?
Petitioner. Commission is for taking the action.
See, therefore, they పై విషయం పురస్కరించుకొని శ్రీమతి కోమటిరెడ్డి శ్యామల భర్త సో అండ్ సో చొప్పదండి గారికి తెలియజేయనది ఏమనగా గౌరవ హైకోర్టు తెలంగాణ వారు WP నెంబర్ సో అండ్ సో 23/2 రోజున మున్సిపల్ కార్యాలయానికి నోటీసు ముట్టినది. పై సూచిక 2 ద్వారా మీ యొక్క ఇంటికి సంబంధించిన దస్తావేజులు, లింక్ డాక్యుమెంట్స్ మరియు భవన నిర్మాణ అనుమతి పత్రములు మున్సిపల్ కార్యాలయానికి సమర్పించటకు నోటీసు జారీ చేయమైనది. నేటి వరకు ఎలాంటి దస్తావేజులు సమర్పించలేదు. దట్ ఈస్ ఆన్ 23/2/2023. దిస్ నోటీస్ సెకండ్ నోటీస్ ఈజ్ ఇష్యూడ్ ఆన్ 28/2/2023. కావున ఈ రెండవ నోటీసు ముట్టిన 24 గంటల్లో మీ యొక్క ఇంటి నెంబర్ సో అండ్ సో దస్తావేజులు సమర్పించగలరు. దానికి మీరు ఆన్సర్ ఇచ్చింది ఏంది? కోర్టులో కేసు పెండింగ్ ఉంది, కేసు డిసైడ్ అయ్యానికి ఇస్తాం పో అని అన్నారు. You see, this is second notice wherein a direction was issued directing you to submit the document within 24 hours. Prior to that, you see reference number 2, wherein the notice dated, a first notice was issued on 23/8/2023 directing you to submit the documents. That is the first notice. Second notice was issued directing you to produce within 24 hours. Your answer is case is see bottom of your note. I am closing the contempt. You pursue your petition. Yes. Yes, sir. This contempt case has been filed. This contempt case has been filed for alleged violation. Number 31, Mr. Surendra Reddy. Yes, Mr. Surendra Reddy. Yes, who is appearing for Surendra Reddy? When they served the counter affidavit? 211. So what is that reply you want to file? What is your case?
They want to convert the TSC license to. But the respondent number 627 rejected the proposal.
On what ground you have rejected?
Respondent number 16, unofficial testimony. Your Worship, the government has permitted TFT into TCS if the members unanimously opt for the same, but they have rejected the proposal.
Yes, it is a request of the Land Council for the petitioner for filing reply. List this petition on 6/12.
Number 32 is the development has to say.
Both connect, both requests.
Number 33, Mr. Venu Kumar.
GP provision and excise. Yes, what is this?
Owner of the vehicle was not meter party, so he has filed an petition. Notice has to go.
No notice has been ordered in this case.
Now he has implemented the respondent.
Notice on implied application. List this case. Petitioner is permitted to take out personal notice in IA number 2 of 2023. File proof of service. List this case on 6/12.
Number 24, Mr. Rahul.
Reply. You want to file a reply? What is the matter?
We are not shifting a wine shop. I think a lot of interest to these petitions.
See, what is their stand in the counter affidavit?
It's fine, they are speaking about the earlier rejection and earlier granting of the license. Earlier, what happened, same present society has filed the petition challenging the action of the respondents.
See, why you are seeking shifting of
Because of the running of the wine shop, I lost my take the photographs taken by parties making a lot of inconvenience to the residents of this apartment as well as the locality people. To that extent, for the purpose of answer this petition, the unofficial respondent, 7th respondent has obtained the consent from the locality welfare association and as well as the temple Millard. They are given no objection recently. The purpose of answer this petition. To that extent, I need to file the
temple has given.
the temple, but the so-called chairman of the temple Millard has given.
How it is binding on the excise authorities?
The reason why
Madam,
Shop owner has not made the party. in
forget about the shop owner. How can you say, Madam, how can you say that the temple authorities, some chairman has given no objection to run the wine shop near to the temple? That is contrary to the rules.
Bishop responded speaking about the temple and
Whether temple is within the 100 meters distance from the.
the contention of the
You are appearing. So the respondent. Yes.
That this has been in existence for the past 32 years.
Forget about existence from spot to whether it is in contravention of excise rules.
That it is, there is no contravention.
According to you, there is no temple and school.
Within the 100 meters, as per the excise rule, within the 100 meters, it cannot be.
Yes.
It is not well within 100 meters.
But there are temple.
Within 100 meters, there is no temple.
In 100 meters.
The excise counter also says that, and previously the inspector, station house have also inspected the property. And also gave a report that not in violation.
No such report are available in the recording.
Filed by the excise, your lordship may kindly see at page 6.
Yes.
Page 6, and whereas station house officer.
Page 6.
Page. Counter filed by the excise.
Yes.
That's the station, in the middle of that.
Yes.
Whereas the station house officer Kashipura inspected the premises and recommended for grant of
Yes.
A4 shop license. You have to send the license in A4 bearing must also issued under Rule 20 of Telangana in favor of the selected.
Station house officer means the excise station house officer or the police station house officer.
Excess station officer. This is with regard to the earlier license. Now this was not present license.
But the rules are one and the same, Mr. Ramlu.
But the limited grievance of the application where they are causing immense inconvenience with regard to the running
The
of.
state is not concerned with the immense inconvenience being caused to the citizens. State is only concerned. State, Mr. Ramlu, state is only concerned with regard to the collection of revenue. That's all. And therefore, they framed a rules under the Provisions of Excise Act, wherein they specifically stated that except from a distance of 100 meters from the temple or the school, remaining all other places, the wine shop license, A4 license can be granted. Whether it is inconvenience for you or your society members or something else is not the botherance of the state.
At least the respondent authorities, official respondent authorities, at least to answer the query.
What is that answer? What is that answer? The answer from the respondent is that there is no violation of the rules. That's all.
And
If you are agreed with the action of the state, wherein it is causing inconvenience to the inhabitants of the locality by establishment of wine shop, you file a public interest litigation saying that state is not having such a power under public policy to frame the guidelines.
Rules may have to be amended, restricted to below.
The rules will be, he is saying that it will be amended even reducing the distance. Now there is a proposal to amend the reducing the distance from 25 meters, 100 meters. Because they wants to, see, state is running, the exchequer is running on the taxes being paid by the wine shop owners, excess duty. And you are aware that nearly about 4,000 rupees, 4,000 crores being collected for sale of applications. Telangana is first in all, either spa centers or the hookah centers or the wine shop and bar shops. We are having our own credit.
Not only this, there are other commercial establishments also.
That's what I am saying. We are in first in all.
So this allegation is that there are traffic jam, not because of this. There are
In allowing the spa centers also. I was told that it is more than Thailand, how Hyderabad spa centers. More than Thailand. Earlier the public used to go to Thailand for spa centers. Now there is no necessity because we have developed in. You want to file a reply?
Yes, because they have given counter.
So whatever may be, now you are know very thoroughly about the where you stands in your case. Since the after filing of the counter.
Most previous official respondents, where I'm making tremendous to reload from 2015 to 2018, they did not answer even my representation. That is only my grievance.
If you want to dispose of your representation, directing them to, I will direct them.
Interim order was there.
No useful, Mr. Ramlu, no useful purpose.
May I invite your lordship attention, sir? But your lordship may kindly go to the.
And you are thinking that the license holder and the excise department is totally a different one. No, they are one and the same. They are two edges of the kind. That's all.
Well, I find formal reply without lordship may kindly dispose the representation. Next week.
Yes, at the request of the land council. List this case for filing reply. 612. Yes, please, Munda. Yes. You are seeking release of the vehicle or Jagri?
Release of vehicle.
Yes. What is the remaining IAS?
Is of Jaggery and release of two-wheeler also they are still.
You file separate application for release of two-wheeler and as well as release of the vehicle.
Yes.
IA number?
3 is for lorry matter, and IA number 2 is for Jaggery matter, IA number 1 is for two-wheeler.
So far as Jaggery is concerned, have you filed any counter affidavit? Saying what?
Is positive, unfit for human consumption.
Jaggery is unfit for human consumption.
That as a letter, my counter and you reply for that.
See, I will dispose the writ petition if they file a counter affidavit. Why in a
You know, the person Jaggery would have the petition on different lorry matter, no correct, but he was carrying the Jaggery matter with the e-way bill, everything is there. He is a proper transport.
but you have to go before the deputy commissioner, file an appropriate application for release of the vehicle.
But till today, no steps were taken by the market. Therefore, I was supposed to upload those honorable government. This today,
What steps?
today they have
You
not.
have sent the already sample which has been seized from you for the chemical analysis, and they have obtained a report. That means they have registered a crime against the vehicles involved and as well as Jaggery.
Yes,
Therefore, you are entitled to make an appropriate application under section 46C of the Excise Act.
with regard to vehicle release, of course, this honorable government for release of vehicle.
You are not only asking for release of the vehicle, you are equally asking release of Jaggery also.
You know what? He is particularly for separate. Where is the money?
Yes.
With regard to item of 22, and they come with the quality. That is quality. 3 marks.
See, laboratory analysis report very specifically says that the Jaggery which was found in your vehicle is unfit for human consumption. It can be used as a raw material in the manufacturing of illicit distilled liquor.
It's a purchase from even metal was not delivered. It was in the lorry only from a 50.
So it amounts to not an offense,
No,
according to you.
It was purchased from under an invoice from the Subulakshmi company, multi-stored.
Therefore, I will direct the police excise department to add your vendor as also party to the.
They are sending on it with the lab report, everything. But to the extent of this, I only request on court with regard to release of lorry man at least.
Release of vehicle orders. The main petition. Same order. Subject to petitioner. What is the model of the vehicle?
19 man, 2019.
2 lakhs.
1 lakh man, 1 lakh man. For 19 model, the value of more than 5 to 6 lakhs.
Lorry, you are saying.
Yes.
What is the capacity? What is the capacity of the lorry? Capacity in the sense is capacity in the tons
Yes,
for carrying the goods. What is the capacity of the lorry?
8,000.
8,000 kgs, 8 tons. That means 8 ton lorry is easily fetches about more than 8 to 10 lakhs.
Second, and 19 model 2002, that is only.
It's 1 lakh. Second one, IA number 3.
One is for two-wheeler, not 5,000 rupees.
See, IA number 2 is for the release of lorry.
Yes. I number 3 is for release of lorry.
IA number 3 is release of final order. IA number 2 is for release of
Material matter.
material you forget about.
Yes, man. Number 1 is for release of two-wheeler matter.
IA number 1 is release of 2-wheeler.
Yes.
This is new vehicle.
Yes.
2-wheeler, this 2-wheeler.
Yes, man. It is 2014 model.
2014, there is no TS09 number, registration number.
2014 model.
No. 2014, there is no TS09. It is only from 2016 onwards.
Thereafter it has been changed.
Yes.
Manufacturing is to.
What is the cost of the vehicle according to you?
Not even 5,000. My client said not to even ask for the let it be.
Therefore, I will dismiss this IA. Let him wait for the final result because it is not cost about 5,000. Why unnecessary?
That is what. I agree.
Elective, this IA may be there along with the writ petition. Yes. When it is not cost of 5,000 rupees value, why should you give a security to those people? Yes. Post IA along with the writ petition and you file a counter affidavit so far as the power of seizure of the Jaggery is concerned. File early counter. What can you do with the Jaggery? You want to produce ID liquor. You want to manufacture with that using that jaggery for ID liquor. For what purpose you will use it? That ID liquor. You want to destroy that jaggery.
Yes.
You want to destroy the jaggery. Whatever jaggery you have seized from the farmers, black jaggery or white jaggery you have destroyed so far. Show me in one case where you have destroyed the jaggery. So far as IMFL is concerned, or ID liquor is concerned, or Gudumba is concerned, you have destroyed. Only for the purpose of status, economic status.
For the orders of the honorable courts below, we have destroyed the.
Orders of the honorable court below. Since you have already, if you produce that the crime property, you will file an appropriate application for release of the same.
Sir, it has been released, Maharaj.
See,
Ganesh traders, the court judgment.
Ganesh Traders judgment said if it is there is no provision of enabling the state to seize the judgment of the Ganesh Traders, the full bench judgment. In terms of the full bench judgment, I will pass an order releasing of the jaggery.
Release of order also passed.
Yes, at the request of the learned government pleaders for filing counter affidavit, list this case on 6-2. Yes. Yes. Yes.
Number 36, Mr. Karthik Nave.
Case. How many cases are there against him? 13 cases. 13 cases registered, 10 acquitted or ended or in compromise in the local adalat, and the remaining 3 are pending. What are the offences registered against? What are the offences in pending cases? Is your habitual offender? 3 cases are there out of 13. So that is not a ground. A surveillance by the police is necessary on you because you are involving every year. Almost all 2013, 14, 16, 17, 3 cases, 19, 3 cases, 18 1 case. You don't have any other business. It is your profession. Therefore, you are an habitual offender. You are not entitled for washing up the rowdy sheet opened against you. And admittedly, as of the date, 3 cases are pending against you. After ending up those cases in acquittal, we will consider your case. Post this petition. 30th December. 30th December holiday unda leda chudandi. Saturday aitunda? 29th. Yes.
Item number 37, Mr. Srinivasarao.
Yes. 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 What is the matter? You are appearing for? What is the response number 4-5? I know that you are unofficial respondents. What is your right so far as interference of the petitioner activities are concerned?
These actions, so many cases pending because.
And the very same time, who filed those cases?
Of the district election, the earlier orders are not applicable to them. The draft said but is a requirement for commercial requirement property of the petitioner also.
So, who are you basically? You rear the fish in the tank. according to you? It is a private tank. It is a private tank. What is your right to interfere with the tank?
We also claiming that the tank clutch, but many cases are pending clutch.
You are claiming tank. It is not situated in the Patta lands.
Is a Patalan part of the land also we claiming.
What is your right to claim? Who are you? The district fisheries department granted fishing rights to whom? To the petitioner. Then what is your right? Page. Page.
The retail order is being copied to the description of the that's try to protect the option like agree by the expedition. Okay, please operate a post.
Yes, earlier in 2011 also there is a direction. What do you say? Just file your counter by the next date. I will dispose the red petition if it is necessary. Yes, list this red petition on 29/11/2023 for filing counter affidavits. Yes.
The official response is
Official respondents also. Bottom. So he is only asking for the police protection for catching of the fish from the tank when there is an objection from the contesting respondents. Fisheries department is not a party.
now that the Gram Panchayat is involved in the property on the text of the official respondent and permission raising of.
Who is appearing for the Gram Panchayat?
Not a party.
Forget about the fisheries department. Who is appearing for the Gram Panchayat?
Not a party.
My agency will not take outside the official respondent is not taking any action. And at this juncture, they are saying that it will make back to the department.
You also file a counter affidavit by the next date. Yes, 29/11.
Number 39, Mr. Shishidharan.
Yes.
Special file, friends of the police and the cases. And then level, it's not twice. It's number 2.
Year number 2 for substitute of service. For which respondent? Yes. A number so and so. File seeking. It is the contention of the petitioner is. A2 लगा इसको. Already filed a charge sheet.
Yes.
It's ready. What is the prayer you sought in this petition? Therefore, they have already registered. They have already registered a case. They have already filed a charge sheet. So far as the police protection is concerned, go before a civil court, not before this court. Right? Yes, right. This petition is filed seeking following relief. Please stop. The petitioner's claims to be question of the land. You have never, you have not claimed that you are owner of the property. You only claims. Read para 3 of the affidavit. The petitioners claims to be owners and possessors of 0.0550 guntas in survey number 256 by Yes,
Due to 53 are filed the party crime.
yes,
There's 41 is filed. Personally, a substitute is carried out.
yes.
But the where that's the major difference.
No, I think rejoinders, in 3 cases, rejoinders are filed today. There are 2 cases, rejoinders that to be filed.
File in all cases rejoinders. Yes, when you want to earn.
It has post 2 weeks.
Yes, list this case. Is there any urgency, Mr. Govind Reddy?
All the 10 cases are before your doctor. They have filed rejoinders.
Lord, may I invite you, Lord?
1 minute, 1 minute. Yes.
Subject to my lord's convenience. We are ready, my lord, to go ahead with the matter. Subject to my lord's convenience, kindly have them on Monday so that we go ahead.
He is specifically asking for the filing of the reply. We'll consider that
2 weeks.
he's asking for 2 weeks. Yes, Mr. Advocate General.
No, I was only making the same request as Mr. Govind Reddy was making.
Yes.
In case there is interim orders governing the fact situation. In the matters where rejoinders are filed, perhaps the hearing can commence. To your lordship.
Let them file the replies. There is no such an urgency now in these matters because it has to be decided not petition. It has to be decided the quash proceedings also. Matter went up to Supreme Court. Supreme Court has now remanded to be decision being taken by the learned single judge where the cases are pending. Therefore, there is no such an urgency. Let them file reply affidavits in all cases, and you prepare the synopsis of the cases, dates and events along with the related convenience set. Subject.
Please, in respect of the cases where rejoinders are filed and pleadings are complete, my lords may consider taking them from Monday.
By piecemeal, what is that urgency in these cases, Mr. Govind? See, so far as the interim order is concerned, matter has been carried to up to Supreme Court. Supreme Court said it has to be finally disposed of. Whatever may be the reason, but the Supreme Court has directed to dispose of the main cases. Therefore, even you forget about the interim orders being carried to the Supreme Court, but now in view of they are asking time to file a reply affidavits. Once the pleadings are completed in all purposes, we will proceed further with the matters instead of piecemeal, because these findings, whatever these facts, whatever we have taken into consideration in the jurisdiction, will be having an impact over other 2 cases also, where they are asking for filing of the reply affidavit. I will give a date. Yes, list these cases on 6/12/2023. Yes, yes, you file it. 6/12 after elections, we will have little patience to hear these cases.
Very well.
Yes, yes, Mr. Advocate General.
Yes, yes, very well, Manoj. Just the humor of your lordships, I was laughing out aloud. I'm grateful.
Yes.
Number 5, Mr. Sharad Kumar.
Mr. Nalini Kumar, you also filed whatever judgments you are relying upon, and the synopsis are the list of dates and events. Whatever you want to relay, you file it. Yes. You are seeking time? Because what is the matter? Hmm?
His husband was in jail. The husband issued a PT warrant in respect of offences below 7 years.
They are entitled. For issuance of the PT warrant, they are entitled. What is wrong in it?
At the point of time, every person.
Yes, what is the matter, Mr.? Where is the judicial officer? Which respondent? Why you added respondent number 15 as a party respondent to this case?
Not to issue PD warrants in respect of the offences punishable.
So judicial officer is not necessary. Whatever orders being passed, it is binding on the judicial officers. Why judicial officer has to be made as a party respondent? It is not necessary for making courts as a respondents in the litigation. By name. By 2 weeks time, first you withdraw that judicial officer from the litigation, then I will consider for granting a time. Have you made any specific allegations or mala fights against the particular officer then without making mala-fides against the particular judicial officer, why you have made him as a party respondent to the writ petition? If he passes any orders, those orders you are entitled to file a revision or appeal. But how you are entitled to make a judicial officer as a party to the writ petition? This court and Supreme Court repeatedly saying that you are not supposed to make the judicial officer as party respondent to the litigation. For example, learned single judge passes an order and you want to make me as a party respondent in the writ appeal. Therefore, why you made him as a party? What do you say? He wants to withdraw. Yes, you withdraw. Here itself now you withdraw. The petitioner seeks permission of this court to withdraw. Which respondent, Mr. 15th respondent? As party respondent to the writ petition. I am not saying anything, just you want to withdraw, that's all. Permission is granted. I don't know. I have only heard both of you, whether he's a 15th respondent, 16th respondent also, I don't know. He's saying that 15th respondent. Have you verified the caste title at least? IA 288, sir. Yes. Petitioner seeks permission to withdraw. The petitioner has filed IA number 2 of 2023, seeking implement of respondents 15 and 16 as party respondent.
Number 43, Mr. Navin.
The petition. The petition was directed us to increase the bypass in the petition challenge the issue of this. We are sending the signatures. It is appealing the hospital site, not the instructions from the financial option. Should be granted 2 weeks time with the.
Yes, sir, the request of the petitioner. List this case on 13/12/2020. What happened to Navin? What happened to Navin? List this case on 29/11.
Number 47, Mr. Satyanarayan. What about Satyan?
Challenging the attributes of the cases in which they find the with all the costs and cases certification. Thereby, it exceeds the necessity to file the rejoinder my lordship. Today we have filed the rejoinder my lordship. Yes, USR number is 1.
What is that relief you are seeking in your petition, madam? Please let them file a reply. It is urgency. There is no urgency. Yes, the petitioner is permitted to file a reply. The petitioner seeks permission to file a reply affidavit. List this case for filing reply on 13/12.
Number 48. That's 14 per.
Hello, I'm online.
Yes, madam.
My lord, we are facing severe problem, threat, even wherever we are living, and we cannot go to our village. And we are facing threat from the police itself, my lord.
See, I have directed the police pending finalization of the writ petition. The respondents 2 to 4 police are directed to examine and consider the representation of the petitioners for providing police protection, duly taking note of the threat perception to the petitioners. Yes, what do you say? On 19/7/2023, I have directed you to provide police protection to the petitioners. Huh? Yes, madam, have you taken any police protection in this case?
Only one, recently they came only once, my lord, for this, the two for the survey, but otherwise they have not provided us any protection.
Yes, you examine and instruct concerned officer to provide police protection to these two petitioners. Yes, list this case on 13/12/2020. I have directed them, the police, to provide the government leader to provide the police protection, madam, in pursuance of
Okay,
the.
madam.
Yes.
Okay, thank you, my lord.
Yes.
Item 49, Justice Shetty Ravi.
Yes.
It is happening. You can say with the respondents 8 to 10.
Yes.
The police officials know that civil disputes.
Yes, what do you say?
We have given representation to police commissioner.
Yes.
Now, unfortunately, notice was not ordered on this 8, 9, and 10. Other victim respondents.
Petitioner is permitted to take out personal notice to the respondents 8 to 10.
8 to 10, also on 7 also.
7, 8, 7 to 10.
10.
And file proof of service by the next date of hearing. List this case on 13/12/2022. Yes.
Not reach the lordship. Maybe taking the court of,
There is, it will reach, madam. If it not reaches, you make it reach. Yes. Item number 78. Yes. When it reaches, you make a mention. Yes.
Item number 15 is
Yes.
he said filing approach to the family court.
Yes.
Filing the false affidavit.
Yes.
Saying a model. The affidavit that she is taking that and a housewife, but originally that she is a employee in the multinational company. That in the same reason, the petitioner is approached to police, submitting a complaint that the police is saying that already order is passed by family court. Unless application to obtain court order, we are unable to take the proper action. That reason, it's our petitioner approach.
No, you have to approach the very same family court. How can you approach this court? It is a matter being passed under MC number 12 of 2021.
Yes.
Go before the same court, file an appropriate.
She is approaching Milat for enhancement of this under court by filing Milat criminal petition of page number 27.
Mr. Abrahamlo. So how the repetition is maintainable? Tell me.
Because to take action to cheat the court.
Therefore, you have to brought to the notice of very same court, saying that she is working as in a multinational company. She is drawing this much of salary. She has suppressed this facts into the affidavit filed in MC number so and so. Therefore, if you take appropriate action, the court will dismiss even MC suppression on the ground of suppression of the fact. How your repetition is maintainable? How can I am entitled to examine all these things in the writ jurisdiction?
No, the police to receive the complaint and register the case against the court.
No, when a matter has been
Then the investigation may be.
when a matter has been seized before the competent court, family court, you have to file an application before the very same court saying that these are she played a fraud on the court by filing an affidavit or deposing an affidavit. Therefore, court would take a appropriate cognizance of the complaint and court will, even if it is necessary, court will direct for an inquiry into the matter. Appropriate application you are entitled to file. Why liberty you seek? Yes, sir. The case of the petitioner is the
Item number 56 and 53. So, Mummy
Yes.
The last occasion, the Sangupur was placed to directly revenue department to file the counter.
Yes.
Still their status quo may be maintained.
Yes.
The status quo is going to be expected that they did file the counter so far.
The status quo granted earlier, interim order granted by this court. 13/9/2023. Is extended for a period of 4 weeks and list this case on 6/12/2020. Yes,
Both minutes.
both the cases.
Plus,
Item number 15, Mr. Manu.
No representation for the petitioner. Yes, what is the matter, Mr. Home? Yes. Stating what? You are not supposed to reject the UOC on the ground that the petitioners another adjacent to the petitioner or retail outlet, other retail outlet is there. That is the judgment of division bench of this court. Yes, no representation for the petitioner. List this case on 29 level.
Item number 60 and 61. Here, Mukram Ali.
Why is seeking transfer of the FIR to the CCSC AD? Yes, Mr. Godfrey. Yes. Stating what? Really? Yes, read relevant portion. Yes, who is appearing for the petition? No representation for the petition. List this case on 6/2.
Item number 62, Mr. Venkataraman.
Yes.
after 3 years, maybe, that generally to in the house of the, it is his mother-in-law, because those is involved in civil cases, because without informing to the husband, the petitioner might be left out India. Because since by filing this petition, by seeking to investigate the matter by police and take proper steps, whether after filing this petition, whether she filed counter also, but without stating where she is living, whether she is studying in further study or to stay in other house. There is no such a details. We find in the counter affidavit stating that the petitioner is objecting her career for further study, but it is not true. The petitioner is having a good family and he is running a shop in Maharaja Plaza. It is a gold shop since 150 years running shop at Charnath.
They are respectful family, and she never requests the husband, I'm ready to go and study in abroad. But the suppressing all the facts before leaving the country, she participated in function also. But in the said reason, the petition only seeking to permit the petitioner to visit the school to look up the child.
You are entitled to go before the family court, not before this court.
I family court to all the petitions.
What happened?
Why I am requesting in the presence of the investigation officer, may I permit to go and see my daughter? Because
You are entitled to file such an application before the family court where the matter has been pending, not before this court. This court is not.
Because the investigation is pending, if I am going to see in the.
Yes.
One
1 minute. This very same complaint. Saying what?
First class registered officer.
Yes, what do you say? Charge sheet has been filed for offences under section 406, 420, 506. Who is A1 in this case? Wife, fifth respondent here. Against her also filed a charge sheet. What remains in this case?
Because the A1 is elect by suppressing the facts.
Therefore, they have stated in investigation everything. It is stated in charge sheet that wherein accused persons colluded with each other within a criminal breach of trust of to cheat LW1 for their wrongful gain, collected 42 tulas of gold and amount and used for their personal needs. Thus, the accused persons A1 to A7 noted in column number 11 of this charge sheet committed an offence punishable under so and so.
Yes.
Then what more you want? Faizun Issa Begum is none other than the A1 who is your wife. Respond number 5.
Yes. What happened?
What forget about your relief has been considered. That you have to go before that you have to file before appropriate application in the very same case. Right? Yes, that is settled now. This writ petition has been filed seeking following relief. Please. Just closes. Grievance of the petitioner stands reduced.
Yes. In the remedies can.
Stands reduced, this petition is closed. Since the petitioner is also paying this court to permit him to visit the minor children, petitioner is entitled to file such an application. Petitioner is entitled to file an application before the competent court for either seeking custody of the children or for visiting, granting visiting rights to the petitioner. In the event of such application is filed, the court below is directed to consider the same and pass appropriate orders in accordance with it.
Item number 63, Mr. Venkatraman.
Yes, at the request of the council for the petitioner. List this case on 6/12.
Item number 64, Mr. D. Ramakrishna.
Yes. Yes, list this case. Counter is 5. How many cases are there against you?
2 cases pending.
Yes, list this writ petition on 13/12/22. Yes.
Item number 65, Mr. Chandrasekhar.
Yes.
This is the matter pertaining to wholesale buyback. First case and respondent number given a copy in the stating that there is no social buyback. The observer on the process.
Yes, right. Where is the instructions counter affidavit?
One is not given.
Give that memo. This writ petition has been filed. Saying the petition is filed, seeking a direction to the second respondent. See, 5/9/2023, when the matter was taken up, there was no representation from the petitioner. Case was directed to be listed on 29/2023. On 29/2023, at the request of learned counsel for the petitioner, the matter was directed to be listed on 11/10/2023. On 11/10/2023, there was no representation, and the matter was directed to be listed today. Today also there is no representation on behalf of the petitioner. This shows that the petitioner is not interested to prosecute the petition. Dismiss the petition for non-prosecution. Yes, Mr. Raghu.
Ma'am, may I please? My
Yes.
lord, in this matter, your lordship's last occasion, this matter when it has come up as directed to file the counter, this they have filed it, my lord. This writ petition is filed challenging the action of the respondent in not conducting an effective and fair investigation and seeking to entrust to an independent investigation agency, my lord.
Yes.
My lordship, for a moment, kindly see the counter filed by the respondent number 2.
Yes.
Lord, just one paragraph will disclose the entire the way they have conducted the investigation in paragraph 6. Paragraph 6 in 50
1
page.
minute. Yes.
Paragraph 6 in internal 5th page, my lord. Since the accused got it, my lord, this
Internal 6.
internal paragraph 6, internal page 5.
Yes.
The accused too confessed to have taken the following gold ornaments on so-and-so basis. They have 6 kgs gold worth of rupees 3.36 crores. My lord, another is 6 kgs of gold worth of rupees 3.50 crores. 1 kg gold worth of 50 lakhs so-and-so. And paragraph 7 is important, man. It is further respectfully submitted that the accused number 2, Naman Agarwal, also confessed that the above gold ornaments were melted with the help of other accused, purchased the properties with the crime proceed. My lord, now the crime proceed, the properties which they have purchased, except alleged to have seized the document, nothing has been done, my lord. Your lordships may kindly say, they further say in paragraph 8. Paragraph 8.
Yes.
In reply to so-and-so, it is respectfully submitted that, as stated about the Mahankali police has seized the property documents and 124 grams of gold and net cash of rupees 2 lakhs so-and-so, so-and-so. My lord, except this, no effective and fair investigation has done it, my lord.
What do you mean?
Seized,
What do you mean effective and fair investigation?
because, my lord, there is no. There are properties, they have given the, how many properties they have identified, which your lordships can see in page 14 of their material paper itself, man. Para 14. Page 14.
Yes.
Page 14. Below.
Yes.
These are the following properties have come out from the crime proceed money they have purchased.
Yes.
Not even, what I mean to say is that, my lord, merely seizing the document does not make any effective investigation, my lord. There is no attachment and there is no any such an order that the accused shall not create any third party interest. Now they are cool, the accused are going ahead with this sale of the properties in spite of repeatedly bringing notice to the investigation officer to take the steps. These properties, my lord, nearly very valuable properties worth of crores of rupees. This is my concern, my lord.
Yes. Yes, what do you say?
The investigation is still in progress. It is too premature to say that the investigation is not subject.
Yes, the learned government is directed to place a report on the progress of investigation by the next date. I will consider that progress of report investigation by the next date. If it really requires, I will allow your petition directing the CBC heading page.
Very well.
Learned government is directed to file a report in progress of investigation by the next date of hearing. This case on 6/12/2023.
Yes, Mr. Jagan Mohan Reddy.
Yes, have you filed any counter affidavit?
So, I am repeatedly on behalf of Petitioner Council, HIGHCOURT.
Petitioner counsel?
Sorry, Respondent Council, HIGHCOURT. So, the council is not ready for a counter of HIGHCOURT can be granted.
Yes, at the request of the land council for fourth respond number 4. This case on 13/12.
Number 70, the Mohammed Abdul Kubi was.
This case for dismissal on 22/11/20. No representation. This case for dismissal. Case.
Item number 71 is
Case.
Not in previous litigation, the acted second respondent and additionally counsel
Yes.
regarding the events that happened in 17/7/2023. Which I
Regarding the events, sir.
events that occurred on 17/7/2023.
Counter.
Counter, but he did not stated what he has done on 17/7/2023.
Which counter you are relying upon?
His counter.
You file a reply
Yes, I have.
stating what? Yes, I have gone through the counter affidavit filed with the respondent, Inspector of Police, Maria Laboratories, the context of the respondent that he had conducted an inquiry at the basis of complaint as it is palpable like. It's true that there is a dispute between the petitioner and respondent in respect of and the respondent again for our highly influenced people and are close to the district minister. They are politicians and they got the SHO list. The SHO was conscious and was aware that the petitioner was in possession of the scheduled property. The petitioner already had applied for grant of Nala certificate. Same was given to him. It is submitted that the respondent filed a petition. What is that you want on 17/7/2023? They have conducted the inquiry on the complaint. You are denying that there is no inquiry on that date.
Actually, current participant demolished my small custody on the property.
Who are the third and fourth respondents?
No, I'm the petitioner.
Who are the third and fourth respondents? Have you taken out any notice to the unofficial respondents? What happened? Have you filed?
They didn't file any.
Notices have been served on them. Notices surveyed as well as the respondent number 3 and 4.
Proof of service not filed.
Proof of service you have not filed. You are permitted to take out personal notice on 5/9/2023. Yes, it is still directed to take out personal notice. File proof of service by the next date of hearing. List this case from personal notice to the respondents 3 and 4 and file proof. Is this case by the next date of hearing? Is this case on 13/12/22?
Number 72, Mr. Aura.
Right. 5/9/2023, the matter was registered. There was no representation for the petitioners. Case was directed to be registered on 29/2023. 29/2023, when the matter was registered, again there was no representation for the petitioner. The case was directed to be who requested. Yes, at the request of the land council for respond number 7 to 9 for filing counter affidavit. List this case on 6 to 8. No representation for the petitioner. Yes. No representation for the petitioner. List this case for dismissal. On 6 to 8.
Number 35. What?
May please. Will not be permitted to appear online.
Yes.
In this matter, actually, it's coming up for reply from the other side, from the police, my lord, the police authorities.
What is your case, Mr. Pasha?
My lord, there is respondent number 3. He is the accused number 3 in 2 FIRs, in 3 FIRs, my lord.
Yes.
Charge sheets have been filed for accused number 1 and 2.
Yes.
In accused number 3, they are saying he is absconding.
Yes.
My lord, his address as per his Aadhaar and so on, he lives 2 minutes from the police station.
Yes.
My writ petition is filed questioning the inaction of the police. Why have they not apprehended him, done anything, taken any action?
1 minute.
Now the 3 cases, my lord, A3 is given 41 year notices, my lord.
A3?
A3 is given 41 year notices.
Yes. If you have given a 41 year notices. Thereafter, what is the steps you have taken for apprehending A3? Yeah, according to the petitioner, charge sheet has been filed against accused A1 and A2. So for A3 is concerned, you have not taken any action. And according to you, you have already issued a notices as required under section 41A of CRPC.
And you are filing the supplementary charge sheet.
When you will file it? Have you already filed it?
No, my lord.
Then why you have not filed it? Why you have not apprehended? What are the allegations against A3? What are the offences being registered in this crime? Section 424(6). Why you have not apprehended the A3? Why you have not apprehended the A3?
Offenses are 7 years, 7 years.
Offences are below 7 years. Therefore, you have issued a 41 notice. He has issued a 41 notice. What prevented you to file a charge sheet against him?
We are filing a supplementary charge.
Why? Why there is a delay of filing supplementary charge sheet, even though FIR being the charge sheet has been against.
Sorry, will not kindly see page number 23. It
Yes.
clearly says accused number 1 and 2, accused number 3, Sai Kiran absconding. That's why I haven't received any further update after this.
You said that so far as the accused number 3 is concerned, he is absconding. When you have served the notice on the third responding?
Latest instructions are put in money, my lord,
No. The offence has been registered in the year on 9/2/2022. And so far as the A1 and A2 are concerned, you have filed a charge sheet on the month of June 2022. Then what are the steps you have taken? Either apprehending A3 or service of notice as required under 43, 41A, or filing completing of the investigation and laying of the charge sheet under 173, or filing of additional charge sheet if any material is available under subclass 8 of section 173. What are the steps you have taken? Why you are unnecessarily delaying filing of the charge sheet against the A3? Because of your delay in your investigation, unnecessarily the CC is pending for trial. CC has been split over against A3.
Yes, sir. Supplementary charge sheet against A3 will be filed.
Supplementary charge sheet will be filed.
Who, sir?
Yes, at the request of the Telangana government feeder, list this case for further instructions on 15/11/2023. We will see on that day.
Obliged, highly obliged.
Number 76, Mr. Rahul Bhaskar.
Yes. Yes. Yes, what do you say? Non-receiving and not initiating the complaint. Counter affidavit has been filed by sixth respondent. Who is the sixth respondent? Chairman and manager of the Singarani College. Yes. What is stated in the counter? Yes, this is only their formal party. Yes. Who is appearing for the contesting party? Who is the contesting parties? That seventh respondent 7 to 9. Where is your complaint? Show me the complaint. Page number 16. Yes, read the complaint. Yes, what do you say? The complaint prima facie discloses that there is a cognizable offence attracting section 420 and 405. Get instructions by Monday. Yes, at the request of the government period. List this case on Monday. Monday number 22/11. Meanwhile, you get a written instructions.
Number 77. Aditya. Shooting of recall until of justice.
Yes.
On the basis of the crime registered in 2000.
Yes.
Even after the 5 years, the reports like which she. Yes, after the registration of the crime belongs. The petitioner obtained a bail, regular bail.
Yes.
In the same year. Because thereafter is sincerely cooperating.
What are the offences registered?
Offences is under 420, 465, 467, 470. Entire issue is with regard to the bank guarantees. Well, the petitioner belongs are given at his hand.
Shekhar? Yes, have you filed any counter affidavit?
Yes.
Stating what?
But they only say that we got file an appropriate application before the sanction.
Yes, you are entitled to file appropriate application before the court.
For a period of 1 or 2 months, we can file an application. But till now, this is also not been filed. It's been for 5 years. Just to get it that para. Rest of the say they did not say anything against the petitioner. They only say para 7 because.
Yes.
I read this. In the relation para 6 to 11 of the even challenge the
What even they followed and you have also is on bail.
He's on list.
Therefore, there is no necessity when he is regularly appointing reserve. Yes.
List. Number 78. Sir, Somendra Reddy.
Why? Why? Your senior? What is the matter? Yes, what is it?
Police are not interpreting the
Randy. We will record their statement and close the repetition. Yes. I am allowing your repetition, recording their statement that they are not interfering. Your relief is the same. See, praying this court to direct the respondents not to interfere. I will record that their statement that they are not interfering. I will close the writ petition. Yes, sir.
This section is not this is issued to the accused and permanent. It's not to produce the original document. I submitted to the section stating that
Stating,
stating that section 91 cannot be issued to the accused.
yes, how can you issue a notice under section 91 to the accused?
My lord, in this case, my lord, on the orders of this honorable High Court, my lord, section, notice number section 91 has been issued that even though it is an accused, my lord,
This court directed you to issue a notice.
Petition number 6537 of 2024.
Yes. Okay. So who filed criminal petition number 6537 of 2023?
In fact, the respondent number 5 complaint.
Yes.
My lord, kind of senior.
So what is the judgment you are relying upon? Here is the judgment.
Petition 73. Has categorically among the person who is accused before the court of produce one, is compared to be a case against himself. Someone should have proceedings taken.
Yes. This court said, following the Supreme Court judgment, that you are not supposed to issue a notice to the accused.
Yes, my lord, that is the second order. But only in this case, my lord, on the orders of the.
Where is that order? Where is the orders of the Honorable Court? Yes. Yes. As seen from the record, absolutely no material has been placed by the public prosecutor to show that any notice was issued to accused number 1 for production of any documents in his possession. Therefore, the investigating officer is given liberty to. You challenge this observation. How you are entitled to maintain a writ petition? There is an observation, right or wrong, by this court, directing the police to issue a notice as required under section. Issue a notice. They never said it is under section 91. You are entitled to question the orders passed by this court in criminal petition number 6537 of 2023, wherein a direction has been issued to investigation agency to issue a notice as required under 91.
In the judgment, it doesn't say section 91. That should be observed.
Where is that copy of the judgment?
Over in the judgment, it says.
They show that any notice was issued to accused number 1 for production of any documents in his possession.
Section 91 is not mentioned anywhere in the judgment.
Section 91 is not mentioned, but what is that procedure? What is the provision which enables the investigation agency to issue notice to the accused? Which provision enables the investigation agency to issue a notice to the accused? Except 91, there is no other provision in law. There is no any other provision is there in criminal procedure code. Is there any other provision in the criminal procedure code which enables the investigation agency to issue a notice? Yes. To issue a notice to the accused. Pleadings.
To go by the observation of this court also, it says that there is no notice has been issued till date. So only whatever is notice is issued.
Pleadings are completed. Citation. WP number 7333 of 2021. In view of the pleadings are completed, is this case for hearing? Yes. I have posted for hearing. We consider. Is this case for hearing after January? After Sankranti vacation. Number 80. Mr. Niranjan Pratap. No representation for the petitioner. No representation for petitioners. This case for dismissal on 29/11. Item number 81, Mr. A. Jagan. There is no shared passwords. You want this court will grant an adjournment. Yes, what do you say, Mr. Raju?
My lord, in this matter, my lord, at night time he had broken the compound wall. I have filed the lorry photograph, bulldozer photographs, and tried to take possession. And he is a rowdy shooter, my lord. He had got many cases against him. A list I have produced before the court. FIR number 122 was issued against him to bind over, and this particular gentleman had filed one writ petition to the High Court, tied up the hands of the police not to act upon, and now at the backdoor method, now he wants to take the possession, my lord.
No, if any complaint, your complaint has been registered by the police.
Yes, my lord. No, they have registered, they have taken two statements, but they say that hands are four cases I have already filed which are pending before the High Court against this particular gentleman.
The petitioner is the suspect in that trial. The petitioner was called to the police station only for the purpose of inquiry.
I will direct not to interfere in civil dispute, but proceed with the investigation in pending crime. Yes, what do you want? Why tomorrow? So what instructions you will have? I am allowing your writ petition directing the police not to interfere with the civil dispute, but if any case being registered against you, I will allow the police to proceed for the investigation in accordance with law. Yes. What do you say, Mr. Raju?
My lord, let the police act upon, my lord. On my complaint, his complaint, but let the police hands not to tie up. Let the police investigate into that, my lord. Let them look into my documents, his documents, but not to high-handedly go away from that.
I will vacate the interim order. I will post tomorrow or whenever you want. If you want, I will post whenever you want. I will vacate the interim order. I will vacate the interim orders, madam, granted by this court. I will post tomorrow or day after tomorrow or after 1 month or after 2 years. Otherwise, I will dispose, directing the respondents not to interfere with civil disputes, but proceed in accordance with law if any case is being registered. Yes. The case of the petitioner is HMT Officers Cooperative Housing Society has purchased the land to an extent of 25 acres in survey number 588, 589, 590 and 591. Almal Village, Kajgiri Mandal, East. The society, after obtaining all necessary permissions, has made this available to plots. An allotted plot number 197 to an extent of 267 square yards to the petitioner, to the petitioner's vendor. And thereafter, the petitioner purchased the said property, and petitioner purchased the said property, and they said the petitioner vendor, and same was purchased by the petitioner, and the registered sale deed dated 23/11/2001. Thereafter, the petitioner made an application to the Greater Hyderabad Municipal Corporation, and said property was assessed for the purpose of collection of house tax, and petitioner is regularly paying taxes to the municipal corporation. The case of the petitioner is fifth respondent, who is not a member of the society. Has filed an appeal on the file of the Deputy Registrar Cooperative Society. And the said authority under the on the file of the Deputy Registrar, file an appeal on the file of the Deputy Registrar, and Deputy Registrar passed an order upon Deputy Registrar, and an order was passed, an order dated 25/4/2015 passed, cancelling the allotment of the fifth respondent. As such, the fifth respondent is not having any right to claim the property. As such, the fifth respondent is not having any right over the property purchased by the HMT officers Cooperative Housing Building Society. This further case of the petitioner when the respondent. It is further case of the petitioner in the instance of the fifth respondent. The respondents 4, respondents 3 and 4 are interfering with the peaceful possession of the petitioner. Is interfering. Fifth respondent is interfering with the position of the petitioner, with the influence of the fourth respondent, and directing the fourth respondent not to proceed with any constructions over the subject property purchased by the petitioner. This court by interim orders dated 23/9/2023 directed the respondents, directed the fourth respondent not to interfere with the possession of the petitioner in respect of house bearing number so and so in interim order so and so in survey number so and so, Hyderabad, without following due process of the law. The learned counsel appearing for the fifth respondent vehemently contended that in the guise of obtaining interim orders, in the guise of interim orders dated 23/9/2023, the fourth respondent is proceeding with illegal constructions, encroaching the property of the fifth respondent, which initiated the petitioner to lodge a complaint on the file of the fourth respondent. This further case of the fifth respondent that the petitioner has not obtained any permission from the local authorities, either for construction of compound wall or renovation of the property which alleged to have been purchased by him through registered sale deed. Since the petitioner is criminally trespassing and causing damage to the property of the fifth respondent, it is initiated to the fifth respondent, which action initiated for filing a complaint on the file of the fourth respondent, and the fourth respondent acting on the complaint has rightly registered the case in crime number 584 of 2023 under section 448, 427 and 506 IPC, and investigation has been taken. The learned ground pleader appearing for the respondent has submitted that acting on the complaint lodged by the fifth respondent, a case in crime number 584 of 2023 was registered against the petitioner under section 448, 427 and 506 IPC, but they are not interfering with the construction activity being carried on by the petitioner in any manner. In view of this submissions, this court deems it appropriate to dispose the writ petition, directing the respondents not to interfere with the civil rights of the petitioner in any manner, except in accordance with law. And if the petitioner presence is required for investigation in crime number 584 of 2023, the respondent police is directed to follow the procedure contemplated in criminal procedure code, contemplated in law, for taking appropriate action. I am disposing. Mr. Razu, have you followed the order?
Oblige, my lord.
I have directed if the presence of the petitioner is required in crime number 584 of 2023, the respondent police is directed to follow the procedure contemplated in criminal.
Yes, my lord. Enough, my lord. Enough, my lord.
Number 82, Mr. Satish Kumar.
Yes.
Well, the last date is almost directed the respondent police to register an FIR. It was directed to be listed only on the point of jurisdiction. Because I had stated that since the plan was hatched at East Maripalli, since the accused placed.
See, even otherwise also, you have to register 0 FIR and transfer to the concerned court for the investigation. See, you can't send a complaint saying that there is no jurisdiction to you. Whatever complaint you have, anybody has lodged, you have to entertain that complaint and register and subsequently transfer the same. What is the difficulty for you? So what are your instructions so far as that is concerned?
It's only point of jurisdiction. They have stated that Sub Inspector of Police, Maratpalli Police Station, have stated that that is not their jurisdiction. They have said that the person is not living in the case.
So what is the complaint you have lodged, madam?
My lordship, I have stated that I have received written threats and oral threats, and I have submitted the clear written threats which show that my lord, I am suffering threat to my life, my lordship. I will see to you, I will come to your house and I will see to you. It is written very clearly, my lordship. And this person is having a very bad criminal history, my lord. He is the son of some impoverished beggars or something. He had been absconding and living as an outlaw for around 10 years, my lordship, after committing several murders. Then he has taken up law and become an advocate. I was not aware of his nefarious past where he has been wanted by the police in several murder cases for several, and he has been absconding for years at a time. But not if I am not seeing from such a person, I am unaware that we are under the impression that he is a decent advocate in robes and roaming in the High Court. And after finding out and seeing this kind of transaction, my lordship, this is a very serious threat to my life, my lordship. It has to be taken more seriously.
Madam, madam, you are an advocate. The accused also, alleged accused also an advocate. Why can't you solve these issues has to be solved amicably?
I am not aware of this person at all, my lordship. I am only calling him as a brother because he is a colleague advocate. My lordship, nowadays we cannot talk to anybody, my lordship. We are unaware of his nefarious past, a checkered past he is having, my lordship. All this kind of language, my lordship, we cannot given, my lordship, there are probably much more worse language that he is from Garinagar, he will bring the Garinagar police to my house, and the way that the police are cooperating with him, my lordship, we see this page number 32 where the PS, my lordship, of East Maripalli has deliberately given me a wrong number, but at the same time directly we go to the East Maripalli police station. Because I'm getting my lordship, that's I have submitted so that this court is aware of the nexus that is lying, my lordship, between the criminals and the police. All the criminals and friends of the police, my lordship, when we are suffering, very serious action has to be taken, my lordship. Otherwise, I am not at all saying that you will come to my house and directly, my lordship, I have submitted the documents and you see, my lordship, page number 32, there that in that postage stamp, the respondent number 1, accused number 1, rather, my lordship, he has said Angelino, which is the name of the East Maripalli.
What are the allegations you made? Where is your complaint, madam?
My lordship, my complaint is in page number here, NH 3, my lordship. Email complaint I have given to the SHO Maripalli police station. Complaint against Advocate K. Chandrasekhar, mobile number, so as for mobile numbers.
Yes, right.
I never even spoke to him, my lordship, in the car parking, in the ladies' car parking, he has someone approached me. And these are all admitted facts, there is no dispute of this at all, my lordship.
This repetition is fine. Seeking following belief. The case of the petitioner is that she has submitted a complaint on the file of the first response. to you, complaint sent to the which police station? East police station or
Actually, the West Maradpalli police station, but the technical Maradpalli police station, where is the Tukaram police station?
according to you, this complaint, according to you, complaint has been received by you. This complaint sent by the petitioner dated 18th September 2023.
It's Maradpalli police.
Your is Maradpalli police. Therefore, first respondent is correctly mentioned. Yes.
When we confine these jurisdictions, the law, we can see the no time when we are going to send it all our time.
Madam, if you have not complied the directions issued by this court, you are very much aware, you are entitled to file an appropriate proceedings, subjecting the respondents therein for the rigmarole of criminal trial in contempt proceedings. Let them answer, see whether it is a police station situated in Maradpalli in Secunderabad or police station situated in HIGHCOURT campus. Once a complaint has been filed, which discloses a cognizable offence, they have to register the complaint as 0 FIR, then they have to transfer to the concerned local police station, whoever having jurisdiction to try. Same order I have passed.
My lordship, they are afraid that they are rotating along the police station.
Nothing.
Yes.
They will afraid of you, but they don't afraid of the complaint. Because they knows the reports being initiated by you by filing appropriate cases, therefore they will be more careful for conducting investigation into the complaints lodged by you. Yes.
My lordship, if any requirement, I find the contempt before the court.
Yes. We don't think so that the police will allow you to give a scope to filing of any contempt against.
My lordship, there has been vast improvement, my lordship.
Yes, call the next.
Step number 83. Muhammad Muzaffar.
Yes.
Pertains to closure of take it after the election.
Yes. At the request of the level council, list this case on 13th. How many cases are registered?
One case is pending. 1995, they are saying 12 cases. Now only one case which is here.
We will consider after elections. Counter affidavit has been filed. Yes.
Just last occasion. We made such a I invited the counter in
Yes.
We have tried it.
Yes, stating what? Have you given a copy, others say? Give a copy now to me. Yes, they have given a copy, Mr. Buchubabu.
Yes.
Now there is a signature, A. Buchubabu, 2/11/2023. Because you are a busy counsel, you might have forgotten to place the counter affidavit in a repetition. Yes, where you have stated about the
And this we can come up with the last part.
yes, right. Paragraph 3, you read.
Paragraph 3, civil nature.
Yes.
16th August.
This repetition has been filed. Seeking following leave. Mr.
No copy was. The mother of the petitioner died due to some incident. At the time of withdrawal the compromise case, father has issued a letter to the in favor of the sons. They have to register the property in favor of the sons, own sons. That is the contents of the complaint. Also may
See, there is no necessity for transfer of any property stands in the name of the mother. Because the natural children will automatically becomes the legal heirs of the mother, not the husband.
Now,
You read the Hindu Succession Act. The class 1 heir to the mother is the son, not the husband. Husband is the binami. Hindu Succession Act never recognized as an husband as owner to the wife's property. Unmante undale pomante povale. నీ పెద్ద మనిషి నీకు తెలియదా ఆ సంగతి?
the logical point is concerned.
Why logical point? When the son automatically entitled for the property of the mother, what is necessary?
He sold the property. That is the logical.
How can he sold this property? You file a cancellation of the sale deed saying that the father or husband is not legally entitled to transfer.
Undertaking violating, that is only
Breach of promise is concerned, your lordship, I take it.
Therefore, they have rightly said it is civil dispute.
Where the promise violence is concerned, Lord. That's my lordship, can you look into my complaint in the page of my lordship?
Page number 15. Superintendent of Police.
What about the first petitioner is charging a duties in the army?
No, ఏది సరే పోనీ కానీ ఎక్కడైనా పని చేయను కానీ నువ్వు కంప్లైంట్ ఇది చదువు. నువ్వే రాసింటావు ఈ కంప్లైంట్. సివిల్, క్రిమినల్, ఇంకేమైనా ఉంటే వాని మీద మొత్తం దేశంలో చట్టాలు అన్ని పెట్టిరి.
నేను రాస్తే ఒప్పుకుంటాను సార్, నేను మాత్రం
చదవండి కంప్లైంట్.
working in the defense, your lordship.
No, whether complaint discloses any prima facie cognizable offence, we will look into, you read the complaint.
సొంత కుమారులం మా తల్లి గడ్డ మీద విజయ వైఫ్ ఆఫ్ రాము మేము అన్నదం చిన్న వయసులో 4 and 2 years సంవత్సరాలు ఉండగా మా తల్లి ఆత్మహత్య చేసుకుని చనిపోయింది కానీ మా అమ్మమ్మ చెప్పినది మా తల్లి ఆత్మహత్య చేసుకున్న వరకట్నం కేసు పశువుల చేసుకున్న సమయంలో నా కొడుకులకు ఇద్దరికి 2 ఎకరాల భూమిని పట్టా చేయగలను అని గ్రామంలోని పెద్ద మనుషుల సమక్షంలో ఒప్పంద పత్రం రాసి ఇవ్వడం జరిగింది. మేము చదువుల నిమిత్తం హాస్టల్లో చదువుకున్నాము. ఈ సమయంలో పండుగలకు ఇంటికి వచ్చినప్పుడు మా తండ్రి గారిని మా పేర మీద ఉన్న భూమి పట్టా చేయబడి చేస్తా అని గత 20 సంవత్సరాల నుండి కాలయాపన చేస్తూ మాట వేస్తున్నాను. మేము పెద్ద మనుషుల సమక్షంలో పిలిపించాడు చెప్తే పట్టా చేయను ఫిర్యాదు చేసుకుంటారు. బెదిరిస్తానంటే ఇంటి భూమిని మాకు తెలియకుండా రైతులపేట గ్రామ నివాసం సర్వే నంబర్ భూమిని బినామీల పేరు మీద రిజిస్టర్ చేస్తారు.
How it amounts to criminal complaint? Tell me. Any of the sentence or word or full stop comma, does it discloses any cognizable offence? It is purely civil litigation. See, if the property, if it is an ancestral property, your clients are entitled for the institution of the suit for partition. If the property belongs to their mother, they are automatically legal, class 1 legalists to the property. If there is an assurance being given by your father by executing in Oppanda Patramu in the way before the elders, you are entitled to enforce the same by approaching the civil court. Then how can you maintain a criminal complaint against your father? Tell
The property is the legal side position.
You can only entitled to maintain a criminal complaint. పోయి వాడిని కొట్టి మీరు 2 దెబ్బలు కొట్టించుకొని వాడు గీకెండు చాకుతోటని పెట్టుంటారు కేసు అయిపోయి. దానికి అట్లా క్రిమినల్ కంప్లైంట్ మెయింటైనబుల్ అవుతుంది కానీ ఆస్తి మంచి ఇమ్మని అడిగినాయి గది హౌ ఇట్ ఈస్ మెయింటైన్. రాపుల్ భాస్కర్ని అడుగు, నువ్వు చెప్తాడు ఎట్లా పెట్టాలి నువ్వు కంప్లైంట్స్. He will advise you how to register the cases. See, none of the allegations in your complaint does it disclose any of the cognizable offence for registration of crime. Tell me. No, you may be true. That will normally happen in the villages whenever the minor children are there, and anticipating that the father would remarry and the children will be have without any property. The elders meeting will be conducted. In elders meeting, they will give an assurance of sharing of the property in the name of the children. There is no dispute. I am not saying that you don't have any right, but you are having a right to when you have become a major.
Last 2 years back.
Therefore, why you are waiting for all these 2 years? The moment you have become a major, you are entitled.
We are not demanding anything.
Why I am saying is, even during the minority period, you have not filed a complaint. That is a different issue. The moment you attain the majority, you are entitled to file a complaint. Why you waited? Why you allowed your father? Why you have not instituted a suit for partition? Why you have not obtained a not to alienation of the property pending adjudication of the disputes? Whether it is a property belongs to your father as a self-acquired property, whether this property belongs in ancestral property, and if it is an ancestral property, even the illegitimate children is having share in the property. In fact, you are a legitimate children being born to the first wife. These are the issues. You are aware. You are a thorough civil lawyer. How can I decide all these things in a? Mr. Buchibabu, you are right.
Transfer to third party. The
multi-litigation will be go on.
In this court,
Until the crime
you are
not a complaint, at least
you are only
directly portal this property.
you are only
Otherwise,
thinking
there is no chance.
you are only thinking about filing up the requisition to protect the interest of your clients. At the same time, this court also having some self-imposed restrictions to entertain the requisition under Article 226 of the Constitution. I don't have any power to convert silver into gold. Our advocates may say that you are having a power to convert silver into gold, but I don't have such a power. If I am having a power, I will convert all the silver into gold to distribute everybody. I don't have such a power.
But we both.
No. It's a purely civil case. No, since you said that there is something else in this case, without even looking into the complaint, I invited counter from the respondents.
Because Lordship, the apprehensions is whether there's a clear Lordship of one point. Whether civil nature they are not intimated to it.
Now I will direct them to intimate me. Yes, sir.
That is only my grievance. Several cases they will say
The petitioner claims to be. Thumbs up, sixth respondent. Mr. No representation. Last occasion name is Juran.
May I
First time-
please, my lords?
Yes, what is?
I'd like to represent Mr. Saifullah, my lords.
Yes.
Item number 85 for the petitioner.
Yes.
My lord, whether the matter is coming up for instructions of the respondent in this matter. my lords.
Yes, what is it?
But in this country, my lord, the crime has been registered, my lord, except conducting investigation.
You are not interfering with civil disputes. In case of the petitioner is that her husband has purchased agriculture land advisory 2 acres in survey number 3 by E, situated at Gangalore village, Ulkal Mandal, by registered document number 2137/2023, dated 5/6/22. It is further case of the petitioner. The names are mutated. The name of the husband of the petitioner. The names are mutated. Further case of the petitioner, after purchasing the property, their names have entered into the revenue records. Further, our prospects and title is also an issue. List. It is further case of the petitioner. Recently, her husband expired, and after demise of her husband, she is continuously enjoying and possession of the said property. Taking advantage of the death of her husband, the fourth respondent started interfering with her peaceful possession, which constrained the petitioner to institute OS number 128/2021 on the file of the principal junior civil judge Jogipet, and the said suit is pending for trial, pending for adjudication. The grievance of the petitioner is the pending adjudication of the said suit. At the instance of respondent number 4, the third respondent is frequently summoning the petitioner and forcing her to withdraw the suit filed against respondent number 4 and enter a compromise and directing to enter a settlement with the fourth respondent as for the terms dictated by him. 11 government period appearing for the respondent has submitted that the third respondent is not interfering in civil disputes in any manner. Is there any complaint lodged by the fourth respondent?
My lord, there is a complaint lodged by the petitioner, my lord. Court report, based on the court report, complaint. Respondent number 3, my lord, a case in crime number 176.
Petitioner has filed a complaint.
Yes, ma'am.
See, interfering with everyone.
Interfering with the civil dispute.
Civil dispute. In fact, the petitioner has filed a complaint, and same was referred by the court under section 156(3) CRPC, and said complaint was registered right in crime number
176 of 2020.
176 of
22.
2022, and only for the purpose of investigation, the petitioner was summoned. But the summoned, and the respondents are not interfering with the civil disputes in any manner. Recording the said submission that the respondent police fourth respondent is not, third respondent is not, third respondent is not interfering with the civil rights of the petitioner in any manner. This petition is disposed of. You see, regarding the said submission, this court deems it appropriate to dispose the petition, directing third respondent not to interfere with the civil rights of the petitioner pending adjudication of OAS number 128/2021 on the file of the principal junior civil judge in any manner, except in accordance with law. With the above observation, the petition is disposed of. Yes.
Obliged, my lords.
Yes, Bhaskar. Yes, follow 41. What is the difficulty?
But in this case, section 306.
Give IPC, right? What is that offense being registered against you? The FIR is there here. First information report is there, page 13. It is 306. Therefore, 306 is attracted. What do you mean read with section 511 IPC? 306, 511, 2 ఉన్నాయి నీ పోనీ దాని అర్థం. Read with means same.
Tried to commit suicide.
That is a different issue. What is that offense being registered in the FIR is the concern of the court. The FIR has been discloses that an offence being registered against you under section 306 with section 511 IPC. Therefore, 306 is attracting. No 41. I will only direct them to follow the procedure. That's all. Yes, right.
I mean, if any person is committed to suicide, if it died, 306 IPC will be attacked.
Therefore, you are having a good case, questioning this FIR to filing a quash petition under 482, stating that the ingredients of section 306 have not been satisfied and there is no death at all, and still the police have invoked the provisions of section 306 with 511. Quash this charge, or you are entitled to file an application under section 216 CRPC seeking alteration of the charges which have been framed after investigation. Yes, Randy. The case of the petitioner.
TSHC 10 years.
Yes.
The file, let me file 11 is there, that is asked.
5 years only according to me. It even IPS.
Suicide, try to commit suicide. He is 9
306 was struck down.
No, 9.
In the Supreme Court.
No.
It says imprisonment of any description provided for the offence for a term which may extend to 1/2 of the imprisonment for life. Section 511. Your right so far as 306 is concerned, it is not attractive. But section 511 says imprisonment of any description provided for the offence for a term which may extend to 1/2 of the imprisonment for life. In this case, it is 10 years. Therefore, according to you, it is 5 years.
Yes, but for abatement of suicide, it is 10 years.
See, unless if it is a suicide, it is a 10 years. But here it is, provision is very clear. If any person commits suicide, according to you, he committed a suicide. He made attempt to commit a suicide. Attempt to commit a suicide is not a commit of suicide. It is only abatement of crime. It's right. This repetition is fine.
advocate to the on the public.
Yes.
The application with the higher education, the lady.
Petitioner is?
And along with this married,
Respondent number 7 is the additional public prosecutor. Petitioner is the teacher. Says there are differences, matrimonial differences.
One side torture by the husband. He has had unfulfilled relations. And he used to bring women home. And she has to put being wife.
So what is that relief you are asking? Tell me.
There is.
No, why you are? What is that final relief you are asking? You are asking for final departmental inquiry. You are asking for removal of your husband. As on the date, he is an husband unless legally divorce has not been granted. You are asking a departmental inquiry has to be initiated against your husband.
Yes.
He has to be removed from the additional public prosecutor post.
For suspension, because he is not allowing any investigation. Because 3 FIR as parents.
Yes.
2 5 by 5.
Yes.
One post AMS 5 by.
Notice has been received by you. Notice has been received by him.
Yes, yes. Notice fire.
You are having 18 years old children.
Yes.
He's a major now, your son.
And she complained. And the box of is facing an inquiry in the box of. They're not allowing any inquiry.
In this case, director of prosecution responded number 4.
Stating what?
Stating the action taken in the inquiry report.
What is the proposal of the director of prosecution ultimately?
There is a criminal case pending.
So what is the proposal against the disciplinary action against the additional public prosecutor? Is there any recommendation for removal from him service?
No, my lord. The promotion for the post of public prosecutor has been deferred, my lord.
It is a service post.
Yes,
it is a continuous service post.
Yes.
What do you say? Which rule says that a person who is acting as an additional public prosecutor, if a crime has been registered against him, he has to be kept under suspension. See, according to the knowledge of the court, if cognizable offense is there, if the police arrested, if no bail has been granted within 42 hours or 24 hours, they are entitled to suspend you pending inquiry.
Discrimination will endanger the society because he is influence the victims also.
You forget about the other. You forget about Mr. Counsel. You forget about the other victims. You think about yourself. It is not the public interest litigation. It is not the public interest litigation case where this court is having power to make certain observations.
Complaint filed by the daughter itself. This was mine.
Case complaint.
Page number 46. This is the complaint written by a 50-year-old daughter, innocent daughter.
She is not your own daughter.
Yes,
No, but this. What is that relief has to be granted by this court? Tell me. See, I am having sympathies with you, no doubt. But the reason is, what is that? What is that relief you are? Have you submitted any complaint to the Bar Council?
Yes.
Code of conduct. Which provision of Advocates Code of Conduct enables the Bar Council? You answer to the query. Which provision of the Code of Conduct rules of the Bar Council enables the Bar Council to take a disciplinary action against the advocate who involved in a woman case? Unless he has been convicted, the Bar Council is not in a position to take any action. It is only an allegation.
Being a victim, a wife complained, but he is so influential when she writes to.
Yes. What do you say? What is the opinion of the Director of Prosecution?
But since the case is pending, that's why no.
Instead of filing all these cases directly, you straight away file a complaint to the police by the daughter, they will act according to the complaint because it is a serious allegations being mentioned in this complaint. Therefore, you prosecute that POCSO case. Why you want to file another case here?
Because he is influencing the system of justice in such a way that
There are so many people who will influence the system of justice. Nowadays, it has become a fashion. Nowadays, it has become a fashion to say that these systems being influenced by the persons.
from 2018 one FIR pending, 2021 FIR pending, 2020 one more FIR filed by the issued order. No,
What is that? What is that order you want from this court? Tell me.
to keep things under suspension so that.
Have you taken personal notice to him?
Yes, yes.
Who is appearing for him?
So far, no.
Sir, proof of service చేసిండు చూడండి. ఎక్కడ పని చేస్తున్నాడు ఈయన పాప?
Postal
Surveyor.
Suspension is not the punishment.
Yes, what is your counter says, Mr. Non-Feeder?
There are cases against him, my lord. Pending arrest.
ఇంక ఈయన తప్ప ఇక దొరకలేదు ఎవడు అడిషనల్ పబ్లిక్ ప్రాసిక్యూటర్ అపాయింట్ చేసుకుని.
My lord, owing to the cases pending in that matter, his promotion, that is due as a public prosecutor, has been deferred.
You are entitled to initiate a disciplinary action. There is a serious allegations and the complaint being lodged by the daughter, none other than any other one. If a wife, if she filed a complaint, we can say something, but daughter has filed a complaint against father. What are court?
Since the cases are pending, my lord, it will be prejudicial. That's why they did not take any.
Who is the concerned police in the that area? I direct the concerned police to survey notice to them.
What is nursing? It's not a cost.
నార్సింగ్ పోలీస్ స్టేషన్ కాదండి నేను అడిగేది అక్కడ ఈయన సత్యనారాయణ గారు పనిచేస్తున్న పోలీస్ స్టేషన్ ఏ ఏరియాకి వస్తుంది అక్కడ వరంగల్లో. I will direct that police, concerned police to survey notice on the fifth respondent who is acting as additional public prosecutor.
Subedar police station.
ये मल्लंग गोरंग वे बोलते इस सुबेदार police station. కోర్టు ఎక్కడ ఉంది అక్కడ?
Tell us Subedar is. Subedar.
Yes, read your counter relevant portion. Counter Rishindra, give a copy of the counter.
Can you see page number 4?
Now his promotion has been withheld by the department. He is eligible for being promoted as a grade 1 additional public prosecutor. That was deferred now.
Why is not? It is not available because he deserted the white and silver. Yes.
Counter affidavit has not been received by you.
No.
Survey copy of the counter affidavit. If you are having a,
Good, just now.
see the paragraph 7 of the counter affidavit.
Who submitted the independence of the criminal case, filing a charge sheet by the police. ISC number 54 compared to 1 for the special box of 4 by the department promotion committee which
23 for preparation of this petition for the first 21, which was proposed the deferred.
They have already taken an action against.
Still, in the office, he is able to influence every investigation.
You lodge a complaint, it will be transferred from that place to some other place.
Can you see page number 23 and 24?
23 and
23 and 24. 27.
yes.
The last paragraph.
Yes. CSE has already submitted a representation to the Honorable Chief Justice. Chief Justice has referred the complaint to the concerned police. Concerned police registered a complaint under the POSCO. And thereafter, the charge sheet has been laid against him. What more you want?
Actually, the relief.
You file a reply to this counter affidavit. Since pleadings are completed in this case, list this case for hearing after Sankranti vacation.
Mohammed
yes. Enforcement of
police protection.
go before civil court.
So many other applications are also pending.
See, if you are seeking implementation of the civil court injunction order, you go before civil court, file order 39. Petition also.
It is maintained.
When a procedure is available under the civil procedure code, you are not supposed to entertain the petition for implementation of civil court judgments. If you want, we will cite 100 judgments. Yes. Page number? Yes. Page number? After these two judgments, Mr. Counsel, after these two judgments, there are two judgments of the division bench of our own High Court in writ appeal number 189 and another is writ appeal number 32. And both the cases, this court said the 226 is not meant for enforcement of the interlocutory orders passed by the civil courts, particularly granting the police aid. Those are the two judgments. One judgment for one writ appeal, I am the party to the said judgment. Following those two judgments, we have disposed of some number of writ petitions.
But here also, what is the
This after subsequent judgment, what is the effect of the earlier judgment? Tell me. You are relying upon the learned single judge judgment. I am saying about division bench judgment in writ appeals. Therefore, division bench judgment is directly binding on me rather than the learned single judge judgment. Go before the civil court, file appropriate application. You are not following. Go before very same civil court, file an appropriate application under Art 39 and 2A, read with section 151 CPC, seeking police aid. And Supreme Court said in 2017 Supreme Court cases, an application filed under section 151 CPC for seeking police protection is maintainable rather than throwing the case under Art 21 Rule 32 of the CPC. Therefore, you are entitled to file an application under section 151 seeking police aid. And if even after filing such an application, if the trial court has not come into the rescue, then you file a writ petition, we will consider.
Some applications were also pending before the civil court. Three of the applications.
I will direct them to dispose of the application filed. Very same relief you are asking before the civil court for police aid.
The other application.
Other applications I am not concerned. What is the relief you have sought in this present petition?
Is the protection of the police aid.
Have you filed such an application before the? Therefore, I will grant a liberty to you to file an appropriate application under section 151 CPC, and if such an application being filed, we will direct the trial court to dispose the same in accordance with law. Within a period of 2 months, I will direct them to dispose.
Because this petition is filed in the month of 2 months back, and having a serious urgency in the rights.
If that is the case, we will do one thing. Have you made the contesting parties as party respondents to the writ petition?
Yes.
Then what happened to the, what happened to the, have you taken notice?
Already taken the notice and filed the proof of service also.
Yes. It is served on all other respondents? It was served.
It is served notice. USR number 90958.
Dispose within a period of 6 weeks. Yes. Directing the trial court. See, there is a procedure being followed. See, there is a procedure being followed by the civil courts when issuing a notices or summons to be contesting parties therein. Within a period of 1 month from the date of receipt of copy of this order. Yes. Disposed of. Disposed of. Yes.